I'm Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Are you the parent of a minor child age 18, under age 18, and have you been or had a disagreement with the custodial parent about when you will see and visit with your minor child? Or has the custodial parent denied you your desired visitation with your minor child or children? Again, that's children under the age of 18. Those will be considered minors. Or has the custodial parent denied you any visitation or temporary custody of your minor child? So, if that has happened to you, how do you resolve this situation? Well, that's the topic on today's broadcast: child visitation and temporary custody. Now, for all of you parents out there, I'm sure that that is a topic that is of some importance to you. So you'll be very interested in today's broadcast. Now, what is your right as to visitation if you're not granted custody of your minor child or children? A parent not granted custody of a minor child or children is entitled to reasonable visitation rights. Reasonable visitation rights unless a court finds, after hearing, that visitation would endanger the child's physical health or impair his emotional development. Now, that is the law as to rights of a parent to visitation and temporary custody here in the state of Missouri, and that is the law in some form or another in other jurisdictions. So you have a right as a parent to reasonable visitation and custody of your minor child or children if a court has not granted you physical custody of your child. Now, as far as resolving the situation when you've been denied the right of visitation or temporary custody with your minor child by the custodial parent, the first thing is you should communicate to the custodial parent what is your desire as to visitation and temporary custody of your child or minor children. Once you communicate your desires to visitation and temporary physical custody, if you and the custodial parent can come to an agreement, then your problem is resolved. Unfortunately, it's not in many instances that easy because custodial parents, and this really is unfortunate, sometimes uses custody as they do support as a weapon, and this really harms the child because the child needs the meaningful contact with both parents, the custodial parent as well as the non-custodial parent. So it is very worthwhile to resolve any disagreement you have with the custodial parent about visitation. In that way, you can avoid having to litigate or go to court to obtain an order for custody and temporary visitation. Now, in cases where the parents are married and then divorced and they have a child or minor children under the age of 18, from the born of the marriage, then the issues as to temporary custody and visitation of minor children is covered by the court by way of a parenting plan. So where you're married and then divorced, then before you can get a divorce and you have minor children under the age of 18, the court will require a parenting plan, and that's a formal written parenting plan, either prepared by the parties during the course of the divorce proceedings, or if the parent can agree, then the parenting plan would be prepared by the court, or in some instances, there may be a court-appointed attorney to represent the children in a divorce, and that's called a guardian ad litem, a court-appointed attorney. In some instances, and these are usually in cases where the parents have a real conflict about custody and visitation, then sometimes it's necessary for the court to hear from a neutral party. So the court would appoint a guardian ad litem to prepare a parenting plan, and the visitation and temporary custody for the non-custodial parent is covered in the parenting plan. So that's a court-ordered visitation and temporary custody schedule. So what is in a parenting plan? Oh, by the way, if you resolve your disagreements about custody and temporary visitation without having to go to court, then I would suggest that you put that in writing, whatever the agreed to custody and visitation. Put it in writing, and both the custodial and the non-custodial parent should sign the agreed to schedule of visitation and temporary custody. And that way you have it covered, and you don't have to worry about filing to obtain a court order for visitation and temporary custody. Now let's get to what's in a parenting plan. If you have any questions or comments about our topic today, you can go to our Facebook page and post your questions or your comments, and we'll take your questions and comments during the course of the broadcast. Our Facebook page, of course, is facebook.com/Raymond Law Live, or you can tweet us at Twitter at Raymond Law Live. So let us hear from you with any questions about today's topic. Now let's go back to our discussion. What's in a parenting plan? Typically, the parenting plan provides for a visitation and temporary custody of the child by the non-custodial parent. Usually the schedule involves alternate weekends, that's every other weekend, from sometime after school usually. And keep in mind that with the parenting plan, the parents can fashion a schedule of visitation and temporary custody by the non-custodial parent in whatever they agree to. So you can work this out, and it's always best to work out a parenting plan. So typically, talking about plans that that's been involved in court proceedings, these are typical plans. I've handled many of those during the course of my practice, and I'm discussing now what's typically included with respect to a visitation and temporary custody plan. So usually it's alternate weekends, every other weekends, usually after school, and minor children are usually school-age children. They're attending school. So the plan may provide, for instance, for a visitation after school, sometime after school, maybe 5 or 6, for instance, in the evening on Fridays from that time after school, 5 or 6 p.m. to maybe Sunday evening, let's say 6 p.m., or in some instances, the parents may agree to overnight visitation beginning Friday evening and until Monday morning, where the non-custodial parent would, following the weekend visitation, would be 2 overnights, Friday night and Saturday night, and sometimes 3 nights, Sunday night. The non-custodial parent would then return the child, or take the child to school, drop the child off from school, and then the visitation, the weekend visitation, would end until the next alternate weekend, which would be 2 weekends after that. So that's typical. Alternate weekends from Friday evening to Sunday evening, or sometimes Monday morning. And that's something that I've seen frequently. And in the parenting plans that the court issues, that's typically what's there. But the parents are free to agree to another temporary visitation schedule or temporary custody schedule. Now, also the parenting plan typically includes holidays where each parent has certain holidays. Now, as far as the holidays, typically the parenting plan provides that the custodial as well as the non-custodial parent alternate major holidays from year to year. So that, for instance, the non-custodial parent has time with the child, that's physical custody of the child, during the, let's say, Christmas holiday, Christmas Eve and or Christmas Day, in, for instance, even numbered years. And then the other parent, the custodial parent, has the Christmas holiday, Christmas Eve and or Christmas Day, in odd numbered years. So that's alternate years for major holidays, so that the child can spend one Christmas during the Christmas holiday, with one parent, the non-custodial parent, and the other holiday, Christmas holiday, the next year with the custodial parent. So they're alternating with major holidays. And so on also with other major holidays that would include, for instance, these are talking about major federal holidays. That would be, for instance, beginning at the first of the year, after Christmas, it would be the King holiday, Martin Luther King holiday, Memorial Day, Independence Day, Labor Day, Thanksgiving, and so forth. Also, typically, the parenting plans include the child has time with the father on Father's Day every year, not every other year, and with the mother on Mother's Day. Also, typically a parenting plan provides that the child spends the father's birthday with the father, and the mother's birthday with the mother. As for the child's birthday, typically the plans provide that the child alternate the child's birthday, spending the birthday 1 year, even years, for instance, with the custodial parent, and maybe odd years with the non-custodial parents, and then so that each parent has their turn with the child on the child's birthday. Keep in mind again that the parents are free to fashion any kind of schedule of visitation or temporary custody as they wish. But if the parents cannot agree, and it's always better to agree, but if the parents cannot agree, then the court will order a visitation plan through by way of a parenting plan. Now, what if the parents were never married and there is not a court-ordered parenting plan providing for visitation and temporary custody through the divorce? So if the parents were never married and they cannot reach agreement as to visitation by the non-custodial parent, then in that instance, it will be necessary for the non-custodial parent who is being denied visitation or temporary custody or both. It would be best for them, or it would be necessary for the non-custodial parent to file court proceedings or initiate court proceedings to obtain a court order setting forth a schedule of visitation and temporary custody of the minor children with the non-custodial parent. And again, if it's necessary for the non-custodial parent who is denied visitation and temporary custody to initiate a legal proceeding to obtain a court order, then in that instance, again, the parties still have the opportunity to agree upon a parenting plan covering visitation and temporary custody, or if they cannot agree, and once a court proceeding is filed, the court will prepare a parenting plan or a guardian ad litem, or if one parent doesn't do anything, then the other parent, i.e. the non-custodial parent who brought the proceeding, they can offer or prepare a parenting plan with regard to visitation and temporary custody. So either way, when the non-custodial parent initiates proceedings, or either parent, to obtain a visitation by court order, then there's going to be a court order for visitation and temporary custody by the non-custodial parent, either prepared by the court or agreed to by the parties, or, as I mentioned before, in some instances it could be a plan prepared by a guardian ad litem who is a court-appointed attorney for the child or the minor children. So what is the duration of a parenting plan providing for a visitation and temporary custody? It is until the child is emancipated, legally emancipated, or when one of the parents brings a proceeding in court to modify a visitation or temporary custody schedule because of changed circumstances. So once it's in place, a court-ordered visitation schedule, it does remain unless it's modified or until the child reaches emancipation. Emancipation, of course, would be when the child reaches the age of 18, or when the child goes into the military, or when the child marries, or there are other ways that a child could be legally emancipated. Usually it occurs most frequently when the child turns or reaches age 18. So if you have a court-ordered child visitation and temporary custody schedule, what happens if one of the parents do not comply with the court-ordered visitation schedule? Well, that would be a violation of the court's order, and the court does require that both parents and also the child comply with the order as to the visitation and temporary custody schedule. Now the child has to comply as well. So it's not up to a child to say that I don't want to visit with or have time with the non-custodial parent. The child doesn't have that option. And the parent does not have the option of letting the child call the shots as to the visitation with the non-custodial parent. So that's very important. The child doesn't call the shots here, and both parents have to comply with the court's order as to the schedule for visitation and temporary custody. What if one of the parent or the child does not comply with the court-ordered visitation and temporary custody? Well, the non-complying party will be in trouble. The non-custodial parent can enforce the visitation schedule by, of course, going back to court. And once they show that there's been non-compliance by either the child or the custodial parent, then the court can do one of two things. The first thing the court could possibly do is to find the non-complying party or parties in contempt of court for violating the court order as to visitation and custody, contempt. And of course, the party alleging non-compliance would have to show the court that the non-complying party has intentionally failed to, or intentionally violated the order and denied visitation to the complaining parent. So they gotta show it's intentional, not that the non-custodial parent was not able to comply because of, for instance, let's say transportation issues or other issues which made them reasonably unable to comply. You have to show that they intentionally violated the court order by denying visitation in compliance with the order or in violation of the order. So that's the first thing. The court can hold the non-complying party in contempt. The second thing, as far as how the court can enforce its order, is by the complaining parent to file a family access motion. Family access motion. Now, those can be filed without an attorney. It's always very helpful, of course, to have an attorney, but if a family access motion is filed, that's one of the ones similar to small claims that it's a little easier for a party to do that without an attorney, and it's an expedited proceeding. You can have, of course, have an attorney if you decide to enforce a violation of a court order for visitation. You can have an attorney as well. I think you'll get through the process much more quickly and much more successfully if you have an attorney to assist you either with a motion for contempt or with a family access motion. Certainly it's always good to have an attorney to assist you. So what happens as far as the kind of remedy if the complaining parent files a family access motion? Well, the court can order a compensatory period of visitation and custody at times convenient to the parent who has been denied visitation, and the compensatory period of time would be not less than the period of time that the custodial parent has denied to the non-custodial parent. And the second thing is the court could, with the family access motion, order the non-complying parent to attend classes, to give them counseling about the benefits of the child having meaningful relationships with both the custodial and the non-custodial parent. So they can order the counseling, so that's designed to avoid or to ensure compliance with the court-ordered visitation. The third thing the court could do, if on a family access motion, is to fine the non-complying party up to $500. So there is a civil penalty that could be assessed by the court for a parent who is not complying with a court order for visitation. $500. So this is serious, and you do want to comply with the court orders as to visitation. And finally, on a family access motion, the court could order that the non-complying parent pay the attorney's fees of the parent who was denied visitation, their attorney's fees for having to take the non-complying parent to court to enforce the court's order as to visitation. So those are the remedies if there's non-compliance by the child or the custodial parent. One is go to court, file contempt proceedings. The other thing is to go to court and file a family access motion. Don't forget, if you have questions about the topic today, you can post them or on our Facebook page, or you can tweet us at Twitter, Raymond Law Live. So those are some good information about visitation and temporary custody. Hopefully this has been helpful to you, and we're going to be winding down the discussion of the topic for today. For those who have watched this broadcast live, I want to thank you for watching and thank you for your interaction. And to those who may watch the broadcast later, I also want to thank you for those who will watch. Now, if you have questions or comments, you can go to our Facebook page, and that's facebook.com/Raymond Law Live, or you can tweet us at Twitter, Raymond Law Live, or go to RaymondLawLive.com. Or if you want to contact us with comments or questions, or you need representation, then you can contact our office also at area code 314-534-2800, or you can contact us by email. That's mraymond attorney, MRAYMOND Attorney at sbcglobal.net. That's our email address. So join us for our next broadcast. That'll be on Tuesday, May 7th at the same time, 6 p.m. Central. And remember, when you fight, know your rights. Thanks for watching. See you next time.